Good evening. Am I audible and am I visible? Good evening. Am I audible and am I visible? Hello, Prerna. I am sorry, but my previous batch too. Huh? Good evening, Shrestha. Good evening, Somaya. Good hello, Hinal. Good evening. I don't know. Today there is some problem with the lighting or something. My face goes all white. No, all of a much of problem. I look like a zombie. I am visible, Nazia. Good evening, Dashwan. Good evening, Nazia. Good evening, Dasha. I don't know. There is some problem with the lighting today. Just wait, huh? Uh, now is it fine? No, my more dead. Wait. There is some problem with the lighting. It is. Oh my god. I don't know what's wrong. Maybe it's the positioning or something is wrong. Something is not right, but I don't know. No clarity at all in my video. You guys, आज थोड़ा सा bear up with the video. There is something wrong. Uh, Hello everyone. I'm sorry, Tanu. I'm not saying everyone by name by name. I mean, not wishing everyone by name. Good evening. Sorry. Good evening to all of you. Somaya, I was actually supposed to take it yesterday only, but I had some issues, some family emergency, so that is the reason I couldn't take it yesterday. So, hello everyone. Shahid, was it you who had asked me a question on ultra wires? You had messaged me. So, hello everyone, good evening. And I am so super excited to conduct this last live session with you all before the exams. And I hope you all are also equally excited to just now finally write the exam, right? Okay, so Shahid, today we will be discussing it. So I guess your question or your query will be answered. Okay. No, Prerna, now I'm visible. It's so nice to hear that you have come to see me. I'm visible on the screen. So I guess you're my old student, obviously. So did you get that question now? Uh, sure, guys. Those who have messaged me on WhatsApp or Telegram and which whoever I have not replied back, uh, tomorrow I'm traveling. Tomorrow night or tomorrow while I'm at the airport, I'll sit and answer all your queries. Okay? Okay, okay. Then no problem. So yeah, we have discussed everything. I mean, I've given live sessions of revisions done. All the questions are also done. So yeah, kind of. Still, you want me to come online live? I'll surely come again live for you all. So let us start. So I'm so happy to see you all and your Josh. Huh? Actually, the problem is no, I am traveling tomorrow, and now the next session I cannot conduct before Sunday, and Sunday is, I guess, 12. I mean, I don't think you all would actually come to attend the class after that, right? Ah, Prerna, now I remember. Yeah, totally, totally. I was thinking that, but I was not sure, so I did not say Prerna. Chalo. Now let's get back. Okay, that whether the session for Indian Contract Act, we will talk about it in a little while. Let's get back to Companies Act. Okay, when a company is registered, it is clothed with legal personality. Explain here. Can I actually, when we talk about the legal personality, can we actually write about the concept of separate legal entity? Can we talk about the concept of separate legal entity? Yes or no? Here we can talk about the concept of separate legal entity, right? So basically, when a company is registered, it is a person in the eyes of law. It is a separate person. The existence is separate from its members, and it is clogged with the legal personality. The members have a capacity. The company has a capacity to contract in its own name, and it need not use the name of the members to make any contracts, right? Yes, you can even talk about exactly Param, and yes, Shahid, you can talk about Solomon versus Solomon concept also, which talks about separate legal entity. ABC Private Limited, oh, I'm so sorry. ABC Private Limited is a private company having 5 members only. All the members of the company were going by car to Mumbai in relation to some business. An accident took place and all of them died. All of them died. So, does the company also die, guys? All the members died, so does the company also die, guys? Will the company also die, guys? Exactly. And do you remember the words of the judge here in this case? Do you remember the words of the judge in this case? Yes, even a hydrogen bomb cannot kill a company, right? Even a hydrogen bomb. Ah, exactly, exactly. That was the word of the judge. Even a hydrogen bomb cannot kill a company. Chalo, anyway. So moving on to the next one. Examine the following whether they are correct or incorrect along with reasons. A company being an artificial person. You all know the rules. The rules are very simple. You are supposed to answer along with me. A company being an artificial person cannot own property and cannot sue or be sued. Is this correct? No. Can we say this is not correct? Can we say this is not correct? Correct? This is not correct. Am I correct? Because the company being an artificial person, yes, the company being an artificial person can hold property in its own name, and it can also sue and be sued in its own name. It can also sue or be sued in its own name, right? A private limited company must have a minimum of 2 members, while a public must have at least 7 members. True or not? Exactly. Correct, guys. So a private company must have a minimum of two members, while a public must have at least seven. This is true because in case of a private company, minimum is two. In case of a public, minimum is seven. What is it for OPC? What is it for OPC? What is it for OPC? Hmm? One or only one? It is only one. And since we are at it, what is the maximum number of members for a private company? I'm talking about maximum. Okay, guys. What is the maximum number of members for a private company? What is the maximum number of members for a private company? Maximum is what? 20. Oops, I'm so sorry. 200. And for this, it is unlimited. Yes. And can we say broadly classifying every company is either a private or a public company? Can I say broadly classifying every company is either a public company or a private company? Yes or no? Yeah, that is for the calculation. Correct. So examine the following whether okay examine the following whether they are correct or incorrect along with reasons. A company being an artificial person, we have already done this, cannot own property and sue or be sued. This is false. Because this is not true because they can actually hold property in their own name. They can even sue other parties in their name or they can be sued in their own name. We have already done this. This was absolutely correct. Yes, it's true. A fixing of common seal on companies' documents is compulsory. So what would be your answer to this? Tell me. See, is it true or is it false? Yes. Is it true or is it false? Why do you say that, Param? Why do you say it's false? Why? Sorry, Shahid. Oh, acha, sorry. Shahid has, okay. Exactly. As per the Companies Amendment Act 2015, you don't need to remember the 2015, the amendment was there. I'm just telling you because those who remember, as per the Companies Amendment Act of 2015, common seal was no longer mandatory. So, if common seal is not mandatory, how can it be compulsory for a company's document to have a common seal? Exactly. Exactly. Syed, Param, Shahid, thank you. As per the Amendment Act, it's not mandatory for a company to have a common seal. So, if I don't have a common seal, how can I actually put it on the document? So, it's not mandatory to put the common seal on the documents of the company, correct? Exactly. Correct. Muralidhar. Correct. Mr. Sunny sold his business of cotton production to a cotton production company, CPL Private Limited, in which he held all the shares except one which was held by his wife. He is also the creditor in the company for a certain amount. He also got the insurance of the stock in his own name. If you remember, the name of the case was Makora versus New Assurance Limited. I think that was the name of the case. Am I correct? Makora versus New Assurance Limited. Just a second, guys. Just a second. Okay. I'm so sorry. In his own name. Now, when we say in his own name, the name of the case was Makora versus New Assurance Limited. When the cotton belongs to the company, the rightful person to take the insurance on this cotton is company. How can Mr. Sunny take the insurance in his own name? After one, but he took it in his own name and not in the name of the company. After 1 month, all the stock of the cotton were destroyed by fire. Mr. Sunny filed the claim for such loss with the insurance company. The insurance company refused to pay the money. Is the, or rather, here they are asking, is the insurance company liable to pay? No, because the property belonged to the, exactly, the property belonged to the company. The rightful person to take the insurance was the company. He had no right to take the insurance in his own name, correct? An employee, Mr. Karan, signed a contract with his employer company ABC Limited that he will not solicit the customers after leaving the employment from the company. But after Karan left ABC, he started up his own company PQR and he started soliciting the customers of ABC for his own business purpose. If you remember Guilford Motor Company versus Horn, right? Guilford Motor Company versus Horn. ABC Limited filed a case against Mr. Karan for breach of the employment contract and for soliciting their customers for own business. Yes, exactly. Mr. Karan contended that there is a corporate deal between him and the company and he should not be personally held liable. The company seeks your advice as to the meaning of corporate veil and when the veil, sorry, corporate veil, and when the veil can be lifted to make the owners liable for the company. So you have to explain obviously the concept of corporate veil and what are the cases where it can be lifted, where the company has been formed to avoid welfare legislations, or where the company has been formed to avoid payment of taxes, or where the company has been is a sham or a fraud, or where to determine the true character of the company. In all of these cases, the wheel can be lifted. A protection of revenue. I forgot to say that. A transport company wanted to obtain license for its vehicle but cannot obtain license if applied in its own name. Therefore, it formed a subsidiary company and the application for license was made in the name of the subsidiary company. The vehicles were to be transferred to the subsidiary company. Will the parent company and the subsidiary company be treated as separate commercial units? No. Can we say the wheel will be lifted here? Can we say the only reason that this company was formed was to get a license through it? Yes. Can we say both the companies will be taken as one? Yes. So this is again the case of what? Separately lifting of the corporate wheels. Nothing is wrong today. Mr. Dhruv was appointed as an employee in Sun Moon Timber Private Limited on the condition that if he was to leave his employment, he will not solicit. Can we say this is the same question as this one? An employee, Mr. Karan. The heading of this? No, 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 not to evade. Agent, where the case was very similar to the case of Mercantile Transport Limited versus British Transport Commission. So again, where the company is formed to act as an agent for the principal. The only purpose that the subsidiary was formed was to act as an agent for the main company. So the only purpose was to act as an agent for the main companies to get the license. Okay, so Mr. Dhruv, should I read out the question? After some time, he was fired from the company. He set up his own business under the proprietorship and undertook Sun Moon Timber Private Limited's prices. On the legal advice from his legal consultant and to refrain from the provisions of breach of contract, he formed a new company under the name Seven Stars Timber Private Limited. In this company, his wife and friend of Mr. Dhruv were the sole shareholders and directors. They took over Dhruv's business and continued it. Sun Moon Timber Private Limited files a suit against Seven Stars Timber Private Limited for violation of contract. They said that the contract was entered between Mr. Dhruv and Sun Moon Timber Private Limited, and as the company has a separate legal entity, Seven Stars Timber Private Limited has not violated the terms of the agreement. Can we say Guilford Motor Company versus Horn, the same case? Yes. Facts are similar to this case of Guilford Motor Company versus. Five persons are the only members of a private company, Flower Fans Limited. All of them go in a boat on a pleasure trip into the open sea. The boat capsizes and all the five die being drowned. Is the private company no longer in existence? It is still in existence. This is not correct because the death of company has perpetual succession, and since the company has perpetual succession, the death of the member does not result in the death of the company. Further, is it correct to say that a company being an artificial person cannot own property and same thing? Can we say this is not correct? Yes or no? Because it can own, we just did it. So here you talk about, yes, perpetual succession. No limit private company is incorporated. No limit private company. Change. It's not about change in membership. Rather, it's more about the death of all the members, right? No limit. I mean, when you write, you talk about death of the members, basically. No limit private company is incorporated as an unlisted company having share capital of 10 lakh. One of the members, Mr. Samuel, filed a suit against the shareholder, Mr. Innocent, for the recovery of his debt against No Limit. So tell me, No Limit private company um, is an unlimited company, unlimited liability company, and Mr. Samuel, who is a third party, wants to sue Mr. Innocent, who's a member of the company. Can he do that? Can he do that? Can he do that? Can he sue? Why not? The reason being, when we say liability of the member is unlimited, the liability of the member is unlimited only towards the company, not towards the third party. Tomorrow, when the company goes into liquidation, the liquidators will have a right to recover the money from the members. But the third party, the creditors, don't have a right to recover the money from the, yeah. Exactly. Members are not personally liable to the outsiders. Tomorrow, if there is the company goes into winding up, the liquidators can sue the members for the money, but the creditors do not have any right to directly go and sue the member. Correct? So, Mr. Samuel will not be successful in recovering his dues from Mr. Innocent. If you remember, when I was teaching you unlimited liability company, I told you the liability is unlimited towards the members, not towards, towards the company, not towards the third party. Something is wrong with me today. I'm again and again saying something wrong. Unlimited liability is towards the company and not towards the third party. Unlimited liability, Nikita, the liability of the member is unlimited. So the liability of the member is unlimited, but his liability is unlimited towards the company, towards the liquidators, not towards the third party. What is the main difference between a guarantee company and a company having a share capital? Well, a guarantee company, the liability is to pay the guarantee amount is only during the course of winding up, whereas the limited by shares company, the guarantee is either during the course of business or during winding up. In case of companies limited by shares will always have a share capital, but a company limited by guarantee may or may not have a share capital. Exactly. Correct, Param Shahid, correct. Okay, there have been a lot of doubts on this thing. I want everyone's attention here. Okay, Mr. A is an Indian citizen. We are going to understand how to interpret here, please. Is an Indian citizen and his stay in India. He's an Indian citizen. Okay, he is an Indian citizen. And during the preceding year, he has stayed in India for 115 days. He appoints Mr. B as his nominee, who is a foreign citizen but has stayed in India for. If you look at the provisions, what the provisions say must be a natural person, Indian citizen, to be a member or a nominee, right? To be a member or a nominee, the person must be a natural person, Indian citizen, whether resident or otherwise. So if you look at these words, Exactly. Whether resident or otherwise. So if I look at this word, okay, if I look at this word, it is very much evident that it is not mandatory for you to be an Indian resident. Indian citizenship is mandatory. So where, and now when we say resident in India, who has stayed in India for 120 days in the immediately preceding financial year. But this is not mandatory. So if he has stayed in India for 115 days, he's an Indian citizen. So can he form an OPC? All of you, can he form an OPC? Yes. So is Mr. A eligible to incorporate an OPC? Yes. Can he give Mr. B's name? Can he give Mr. B's name? As in Sonia, sorry, Somaya, I did not understand you. B is a foreign citizen. And Indian citizenship is mandatory to be a member or nominee. So, can he be a nominee? No, that he cannot be. Got it? That he cannot be, exactly. And if there is any contravention of this section, punishable with fine which may extend to 10,000 and further fine of 1,000 for every day of default, right? Now moving on to the next one. Rohan incorporated an OPC. The memorandum stated the name of his brother Vinod as a nominee. However, Vinod is starting his new business abroad and needs to leave India permanently. Due to this fact, Vinod is withdrawing his consent of nomination. Taking it, is it mandatory? Well, as long as he is a resident, he is an Indian citizen, it's not mandatory. So it is not mandatory as long as he is Indian citizen. It's not mandatory, right? Can Rohan make his 17-year-old son as a nominee in such a case? No. A minor cannot be a member or a nominee of an OPC. So Vinod need not withdraw and cannot make his 17-year-old son as a nominee. Mr. R, this is the same question, just the days are different. Mr. R is an Indian citizen, whereas Mr. S is a foreign citizen. Can Mr. R, Ananya, did you understand why it is no, he need not withdraw? Ananya, did you understand why is it that he need not withdraw? Okay. So, now, can he be the member of the OPC? Yes. Can he be the nominee of the OPC? No. Why? Because he's an Indian. Here, both have stayed for 120 days or more. So, the days is not even something to be looked into. Anyway, days is not an important criteria because it's whether resident or otherwise. Did you understand? So, R is eligible to incorporate, but S is not eligible to be the nominee of the OPC. Naveen incorporated an OPC, making his sister Navita as a nominee. I've done this question in the class so many times, and like we have done this question. Navita is leaving India permanently due to her marriage abroad. Due to this fact, she is withdrawing her consent of nomination in the said OPC. Taking into consideration, is it mandatory for Navita to withdraw her nomination? Is it mandatory for Navita to withdraw her nomination? No. As long as she's an Indian citizen, it's not mandatory for her to withdraw her nomination. As long as she's an Indian citizen, it's not mandatory for her to withdraw her nomination. If Navita maintained the status of resident in India after her marriage, can she continue to be the nominee? Well, as it is not mandatory for her to be an Indian citizen, it doesn't make a difference of whether she is a Indian resident or not? Because OPC is a very favorite question of the institute. Did you understand this or should I explain something again? So far, is it clear? Everything is clear. First, a few answers. I had more bloopers than correct answers. I mean, then giving the answer straight away, I had more bloopers. So I hope it's clear to everyone. Do you have any doubts? Otherwise, can I move forward to the next question now? Okay. Mr. Anil formed an OPC on 16th April for manufacturing electric cars. The turnover of the OPC for the financial year ended was about 2.25 crores. His friend Sunil wants to invest in the so they decided to convert it voluntarily. Can Anil do so? Yes. Actually, this question was more relevant. Earlier, they had a slab of turnover that your turnover cannot increase on this point. So then this, this whole concept of turnover was there. Anyway, as of today, we don't have any slabs of paid up capital or turnover in case of an OPC. So can it convert voluntarily? And also there was a restriction on conversion of OPC to another type of company. Now there is no such restriction. So can it convert? They are saying private limited company, so we don't need to talk about it. Yes, they can convert into a, so can convert the OPC into a private limited company. Okay. Explain the concept of dormant company. Basically, a dormant company or an inactive company is formed for a future project or to hold some assets, including intellectual property. And these companies, they do not have any significant accounting transactions. What is significant accounting transaction? What is significant accounting transaction? Significant accounting transaction is any transaction other than payment of fees made to the registrar first, payment of any payment made to fulfill the requirement of this act or any other act. Third, any allotment of shares to fulfill the requirement of the act or any maintenance, any expenses for the maintenance of office and records. Which provisions are you talking about, Nikki? So they are talking about whether it can convert into a private company. So what will be my provision? An OPC can at any given point of time convert into a private or a public company and accept a section 8, right? That is the provision because there is nothing else to say. This is the only provision that is there. Nothing else is. What are the significant? I'm sorry. I think I told Shahid that you don't have to mention about not a Section 8 company. But anyway, this is just one line provision. So even if you write, doesn't make a difference. There is no harm in writing that. So anyway, what are the significant points of Section 8 company which are not applicable for other companies? Explain. Okay. So these companies are formed to, what do you say? To promote any sports, science, arts, religion, charity, commerce, technology, environment, or anything. They don't have any minimum capital requirement. They need not use the word limited or private limited after the name. They do not declare dividend to their members. Then they have to obtain a license from the government to operate as a Section 8 company. Even a partnership firm can be a member of a Section 8 company. If it fails to fulfill the conditions, the license will be revoked. In case of a normal company, they have to give a 21 days notice to call a meeting, whereas in case of a Section 8 company, you can call a meeting by only giving 14 days notice. On revocation of license, the company may be amalgamated or maybe wound up or maybe converted to a private or a public company. Can we say whatever we studied under Section 8, every point has come here basically? State whether a non-profit organization can be registered as a company. If so, what is the procedure adopted? Um, huh. So, such companies are formed to promote sports, science, arts, religion, charity, commerce, technology, environment. They do not distribute dividend. They declare do not, and they reinvest the profits into the business to promote the objects. To get a to get a license under Section 8, they have to apply to the central government. On such registration, they need not use the words limited or private limited after the name. And once they are registered, they enjoy many privileges. What do you mean by companies with charitable? Oh my God, under the Companies Act. I'm not going into this again. We've already discussed it. Right? Mention the conditions and revocation of license. Revocation of license if the company uses the objects or acts against public interest, or acts against the does not fulfill the conditions subject to which the license is issued, or acts fraudulently, the license will be revoked. On such revocation, the company must either convert into a private or a public company, or it must amalgamate another Section 8 company, or it may be ordered to be wound up. Please, we have already discussed all the other points, so not going into it. A company registered under Section 8 of the Companies Act earned huge profits during the financial year ended 31st March 2018 due to some favorable policies declared by the government and implemented by the company. Considering the development, some members of the company wanted the company to distribute dividend. अरे भाई यहाँ choice नहीं है, cannot distribute dividend to the members. They approached you to advise them about the maximum amount of dividend. They cannot declare dividend. Such company is not allowed to declare dividend. Thus, the contention of the members is incorrect. Correct? Mike Limited Company incorporated in India, having a liaison office at Singapore. Explain in detail the meaning of foreign company and analyze on whether Mike Limited would be okay. Tell me. Exactly, correct. Tell me, can we call Mike Limited a foreign company? Why no, Shrestha? Why no? Exactly. Just the moment you see a liaison office in Singapore, oh, it's a foreign company. No, it was incorporated in India. Whereas for a foreign company is incorporated outside India and has a place of business in India. This is incorporated in India, having a place of business outside India. This is not a foreign company. Yeah. Define OPC and state the rule regarding its membership. Can it be converted into a Section 8 company or a private company? So I'll just give all the rules here so that if we again get a direct question on OPC, we don't have to go into this again. Only a natural person who is an Indian citizen, whether resident in India or not, can be a member or nominee of an OPC. Resident in India means who stayed in India for at least 120 days in the immediately preceding financial year. The name of the nominee shall be mentioned in the memorandum, who shall, in the event of death or incapacity of the member, become the member of the OPC. A written consent shall be taken from the nominee, and this consent shall be filed with the registrar. The nominee may withdraw his consent, the member may change his mind. If by virtue of a person can be a member of one OPC, only one OPC, and at the same time a nominee of one other OPC, but only one. If a person becomes a member of more than one OPC, and this can only happen because of nomination, by virtue of nomination, he must within 180 days select any one OPC. Now there are certain restrictions. A minor cannot be a member or a nominee of an OPC. The OPC cannot invest in the securities of any body corporate. It cannot incorporate as or convert into a company, or it cannot carry on the activities of an NBF. Correct? So can it be converted to a Section 8 company? No. Private company? Yes. Jagannath Oil Limited is a public company having 220 members, of which 25 members were employed in the company during the period 1st April 2006 to 28 June 2016. They were allotted shares in Jagannath Oils Limited first time on 1st July, which were sold by them on 1st August 2016. So they were employees till 28th June 2016. They sold shares. They took the shares when they were employees. but they sold shares on 1st August 2016. Now, till the time you are employee and you have taken up the shares, or you are ex-employees and you have taken the shares when you were employee, you will not be counted. But after you leave the employment and then you take up the shares, you will be counted. After some time on first, so the total number of members was 220, of which 25 were members. Now, after some time, on 1st December, again on 1st December 2016, they acquired the shares. On this day, were they members of the company? Okay, thank you, Param. Were they employees of the company on this day? Were they employees of the company on this day? No. So we will count them or not count them? So we will count them or not count them? So we will count them, right? Because they acquired shares when they were not employees. So we will count them. So when we count them, the number of members is how many? Ananya, when they acquired the shares, they were ex-employees, but they are no longer employees. If ex-employees had acquired the shares when they were employees, we don't count them. But here they have already parted with the shares, and when they purchased the shares on 1st December 2016, they were not the employees anymore. So we will count them. So how many are there? 220. So the number of members cannot exceed 200. So do we have to reduce the number of members? Yes. What would be your answer if they were employees till 2017? If they were employees till 2017, so when they acquired shares on 1st December 2016, okay? When they acquired shares on 1st December 2016, they were, I repeat again, when they acquired shares on 1st December 2016, they were employees. So they will not be counted. So what is the total number of members? 195. So do we need to reduce the number of members? No. Is it clear? Exactly. Tanushri, did you get it? Why it is not required to reduce? Correct, Heenal. Flora Fauna Limited was registered as a public company. There are 230 members in the company. Directors and their relatives, do we count them? Yes. Employees, we don't count them. Ex-employees, shares were allotted when they were employees. We don't count them. 5 couples holding shares, so we count them as 5. And others is 5. What is the total? 200. Do we need to reduce the number? No. Can they convert into a private company? Yes. Do we need to reduce number? No. Why we don't need to reduce number? Because up to 200 is allowed, right? Yes. A, B and C have decided to set up a new club by the name of ABC Club, having objects to promote welfare of the Christian society. They planned to do charitable work or social activity for promoting the artwork of economically weaker section of the Christian society. The company obtained the status of Section 8 and started operating from 1st April. However, on 30th September, it was observed that they were violating the objects of its objective clause, due to which it was granted the status of a Section 8 company. Discuss the powers that can be exercised. Can we say the central government may revoke the license? And when the license is revoked, either convert to a private or a public company, or amalgamate with another Section 8 company, or winding up. Exactly, correct. A company registered under Section 8 has been consistently making profits for the past 5 years after a major change in the management. Few members contended that they should receive dividend. Can the company distribute dividend? No. If yes, what is the maximum percentage? And if high, they cannot distribute. The company kept a general meeting by giving 14 days notice. Is it valid? Yes. Normal companies, they have to give 21 days notice, but a Section 8 company only has to give 14 days. So is it valid? Yes. I hope everyone is following. Alpha School started imparting education on the 1st of April 2010 with the sole objective of providing education to children of the weaker society either free of cost or at a very nominal fee depending upon the financial condition of their parents. However, on 30th March, it came to the knowledge of the central government that the school was operating by. Do I need to discuss it? Exactly, same answer, so I'm not going into this. Narendra Motor Limited is a government company. NML is a government company. Shah Auto Private Limited is a private company having a paid up share capital of 10 crores in the form of 10 lakh shares of 100 each. Narendra Motor is holding 5 lakh 50,000 shares of SAPL. So advise whether SAPL is a government company. Now, can we say it is the subsidiary of Narendra Motors Limited or it is a subsidiary of a government company? Yes. Yes. So, subsidiary of a government company is a government company. Correct? Explain the classification of companies on the basis of control. On the basis of control, on the basis of control, we have holding, subsidiary and associate. A company is said to be the holding of another, or a company is said to be the holding of one or more other companies if such one or more other companies is a subsidiary. A company is said to be the subsidiary of another if such other controls the composition of the board of directors, holds more than half of the total voting power either on its own or together with one or more of its subsidiaries, provided it should not go beyond the layer specified. Associate company, a company is said to be the associate of another if such other has a significant influence over it, not being a subsidiary, and includes a joint venture. Correct? SK Infrastructure Limited has a paid up share capital divided into 6 lakh equity shares of 100 each. 2 lakh shares of the company are held by central government. So how many shares it has? 6 lakh equity shares, of which 2 lakh is held by the central government and 1,20,000 is held by the government of Maharashtra. Is it a government company? So how much is it holding? 3,20,000. What is 51% of 6 lakh? What is 51% of 6 lakhs? What is 51% of 6 lakhs? Achha, it is holding 53.34%. And to become a government, at least 51%. So yes, it is a government company. Correct? Thank you, Nikita, for the exact calculation. 51% of 6 lakh would be 3 lakh 6,000 and it is holding 3 lakh 20,000. So yes, it is the what? It is a government company. ABC Limited has allotted equity shares with voting rights to XYZ worth 15 crores and non-convertible debentures worth 4 crores. ABC has issued 15 crores and for during the financial year. After that, the total paid up capital of the company is 100 crores and debentures is 120 crores. Right? So debentures are not, so they are asking whether it is a associate company. Well, debentures are not taken into consideration for associate company. For associate company, at least 20% of total voting power. Now, debentures don't give you voting power. Voting power is given by equity shares. Equity shares is 100 crore. If you are holding at least 20 crores of the equity shares, then we can say at least 20% of the voting power. Here, how much is it holding? Only 15 crores. Is it associate? No. Did you understand, guys? The paid up share capital of RAM Limited is 10 crores in the form of 7 lakh equity shares and 3 lakh preference shares. Lakhan Private Limited is holding 3 lakh of equity shares and 3 lakh of preference share. Is it holding subsidiary? Tell me. I've taught you so much of holding subsidiary. Now you only tell me. Chalo. Yes, Lakhan is holding company. Are you sure? It's no, no. Voting power, they are saying, no, when we say voting power, we don't count preference shares, right? We don't count preference shares. More than half of 7 lakh. He's only holding 3 lakh. So is it holding subsidiary? No, exactly, not holding. So as it does not exercise more than one half of the total voting power, it is not a subsidiary. Correct? BC Private Limited and it's should I hope it's clear. I hope it's clear. BC Private Limited and its subsidiary KL Private Limited are holding BC and KL are holding 90,000 and 70,000 shares respectively in PQ, and the total shares of PQ is 3 lakh. So for holding subsidiary, and what is the relation? This is the holding of KL, right? Which one you want me to explain again, Hinal? So BC, if I take alone, it is not holding more than half. If I take KL alone, it's not holding more than half. But if I look at the definition of subsidiary, what it says is either on its own or together with one or more of its subsidiaries. So whatever my subsidiary is holding belongs to me. So my total holding is 1,60,000. Total shares is 3 lakh. More than half is more than 1,50,000. Is it more? Yes. So BC is the holding of PQ. What would be your answer if the entire 1,60,000 was held by KL and nothing was held by BC? So basically now they are saying what would be the answer if entire 1,60,000, if entire 1,60,000 was held by KL and BC was holding 0. Whatever is given, it's given either on its own or together with one or more of its subsidiaries. So whatever belongs to my subsidiary belongs to me. Even if I'm holding 0, because this is my what? My subsidiary is holding more than half. Can we say this becomes the layer BC holding of KL, KL holding of PQ. So BC holding of PQ. So the answer would be the same. Correct or not? The previous question Ram Private Limited had a share capital of 10 crores, which was divided into 7 lakh equity shares and 3 lakh preference shares. Right? Of this, Lakhan Private Limited was holding 3 lakh equity and 3 lakh preference. Now my first question is, for holding subsidiary, Hinal, for holding subsidiary, do I count the preference shares? Hinal, do we count the preference shares for holding subsidiary? Hinal had a doubt and she's only disappeared. For holding subsidiary, preference shares are not counted. So we need more than half of 7 lakh, that is more than 3,50,000 shares. But Lakhan is holding only 3 lakh shares, so it is less than 50%. So it is not the holding subsidiary. I hope now you've got it, Hinal. Did everyone get this answer or should I explain it once more? Popular Product Limited is a company incorporated in India having a total share capital of 20 crores, which is divided into 12 lakh equity shares and 8 lakh preference shares. The share capital, Delight Products, Happy Products and Cheerful Products are holding 2.5, 3.5, 2.5. But the problem is they have not specified which shares. Put your preference. When nothing is specified, so I have no option but to consider more than half of 20. So that wouldn't be a right thing to do. So either I would make an assumption that the shares held are equity, or I will just take more than half of 20, more than half of 20, which is more than 10. Which is more than 10. Now they all are the subsidiaries of Jovial Limited. So that means Jovial is holding all of this. That is, Jovial is holding 8.5, but it is less than half. So can we say on the basis of holding, there is no holding subsidiary relation? Correct? But what the question is saying is, can Jovial be termed as subsidiary of Popular if it controls the composition of directors of Popular? Well, now they are saying that Jovial is controlling the composition of the board of directors. So, is Jovial subsidiary? Well, when Jovial is controlling the composition of the board of directors, how can Jovial be subsidiary? Jovial is not the subsidiary. Rather, we would say that Jovial here is the holding. Jovial here is the holding. Is it clear? Correct? Right? The Articles of Association of XYZ Limited provides that the Board of Directors has the authority to issue bonds provided such issue, because they have not given which type of shares they are holding. They have not given which type of shares they are holding. Nothing is given here. Has authority to issue bonds provided such issue is authorized by the shareholders by a necessary resolution. The company was in dire need of funds and therefore it issued the bonds to X without passing any such resolution in the general meeting. Can Mr. X recover the money? No, Param, it would be okay, but you have to make a note of it that assuming that the shares held are equity. But generally avoid making such assumptions if not necessary. And here there is no point also assuming, because after everything they are talking controls the composition. So better don't make assumption here. But still, if you assume, you have to make a note of the same. Can Mr. X recover the money? First of all, the company was authorized to issue bonds provided a resolution was passed. As an outsider, I only have to see whether the company has a right to issue or not. How it got the power to issue is not my concern. Whether you pass the resolution or not, whether the authority, the requirement was done or not, that is absolutely not my concern at all. The rule of indoor management, right? The rule of indoor management. So I repeat again, can Mr. X recover the money? You're supposed to answer. Can he recover the money from the company? Yes. Because as an outsider, he just has to check whether the company has a right to issue the bonds or not. How the right was given was not his concern. Correct? AK Private Limited borrowed 36 crores from BK Finance. However, as per the memorandum, the maximum borrowing power of the company is 30 crores. Whether AK Private Limited is liable to pay the debt. Now, can we say, since it's a clause given in the memorandum, borrowing more than the authorized amount, can we say it is ultra vires? Yes or no? Can we say it is ultra vires? But they are allowed to borrow up to 30. So can we say up to 30? Okay? Can we say up to 30 BK Finance can recover? But for the rest, the finance company cannot recover the money from the company. Yes or no? For any act which is ultra vires use of the funds of the company, yes, the directors are personally liable. So, for the 30 crores which is allowed, they can recover the money, but for the rest of the money, oof, something is wrong today. They cannot recover. I hope it's clear to everyone. Yes? Briefly explain the doctrine of ultravires. Doctrine of ultravires says that when a company does anything which is outside its authority. When we say ultravires, the name of the case was Ashbury Railway Company versus Ritchie, and the company borrowed beyond, the company made a contract to lend money which was not within the powers of the company. The court held that the consequences are that the contract is void ab initio. Even the whole body of shareholders cannot ratify it. When a single member can sue the company, and for any utilization of funds ultra vires, the directors are personally liable. Correct. Mr. X had purchased some goods from Messrs. ABC Limited on credit. A credit period of 1 month was allowed to Mr. X. Before the due date, Mr. X went to the company and wanted to repay the amount due from him. He found only Mr. Z there, who was the factory supervisor of the company. Mr. Z told Mr. X that the accountant and the cashier were on leave. He is in charge of receiving the money and he may pay the amount to him. Mr. Z issued a money receipt under his signature. After 2 months, the company issued a notice to Mr. X for non-payment. Mr. X informed the company that he had already cleared the dues and he was no longer responsible. He also contended that Mr. Z is an employee of the company whom he had made the payment, and he trusted the words of Z, as duty distribution is a job of the internal management. Tell me, whose contention is correct? Mr. X saying this is correct, or the company has a right to recover the money? Since he was a factory supervisor, making the payment to him was absolutely correct. So as far as X is concerned, he has already paid the money. So Mr. X's contention is correct, and yes, he is free from his liability. Little under the weather today, so please bear up with all the glitches that is happening with me today. Yes. Ah, Tanushri? Exactly. Indoor management. You'll write about indoor management here. Tanushri, company can recover or cannot recover? Okay. If an assessee was a wealthy man earning huge income by way of dividend and interest, he formed three private companies and agreed with each to hold a block of investments as an agent for them. The dividend and interest income received by the companies was handed back to F as pretended loan. This way, F divided his income into three parts in a bid to reduce his tax liability. Yes, Somaya, then it will not apply. Yeah, protection of taxes. Can we say this is the case of Sir Dinshaw Manikji Petit or Jugilal versus Income Tax Commissioner? Yes, exactly. So the case was Sir Dinshaw Manikji Petit. Afrin, actually, there was what you are saying is correct. Ravi Private Limited has borrowed 5 crores from Mudra Finance. This debt is ultra vires the company. Examine whether the company is liable to pay this debt. Can we say, since it's ultra vires, can we say the company can be held liable for payment of that part of the debt which is within the powers of the company? Can we say company is liable to pay only that part of the debt which is within the powers of the company? Yes? Okay. State the limitations of doctrine of indoor management. When we say limitations, you have to write about the lochas, that is knowledge of irregularity, negligence, no knowledge of no, no knowledge of MOA or AOA, and forgery. Soumya, since he was a part of internal management, since he was the factory supervisor, he was a part of the internal management. It is not negligence here. Had I said it was a security guard and you paid the money to him, it would have been negligence, right? If it was you give it to the security guard, it would have been a negligence. If you give it to the peon, maybe it could be a negligence. But he was a factory supervisor. He was a part of the management. No? Huh. Articles of Association of XYZ Limited provides that the board of directors can take loans of up to 50 lakh for company by passing board resolution. More than that, special resolution is required to be passed. Negligence, knowledge of irregularity, no knowledge of MOA or AOA, or forgery. So basically, knowledge of irregularity. Let us say company was not allowed to do something. Let's say company was, you want me to explain everything in details, Nikita? You want me to explain all the cases in details? The director of the company was not allowed to give loans of more than 50,000 without the consent of the shareholders. The director gave loan to the company without shareholders' consent 80,000. Now he says, oh, yo, indoor management, you should have been careful. When it comes to outsiders, we can say indoor management, but you are a part of the management. Can you claim any relief? Can you claim any relief? No. You go to buy a house and you give 5 lakh advance money to the security guard, saying that I was supposed to give it to the officer. Officer of the company and security guard is not the same thing, right? It's your negligence. Remember Hasina Banu, forgery signature. Even though she is innocent, but forgery is one thing which will not give you any right whatsoever. I hope it's clear. You still want me to explain anything? I'll explain. By passing the board resolution, in the case where the loan amount is in excess of the limit, special resolution is required to be passed in the general meeting. Due to urgent need of funds, board of directors applied for a loan in a reputed bank for 60 lakh without passing the special resolution. Board of directors give an undertaking to the bank that the special resolution has been passed. Later, the company denied the payment. Can the company deny the payment? No, indoor management. I am under the impression that you have taken the consent, and they have given in writing that yes, we have taken the consent. And they even gave in writing, right? They gave in writing that yes, we have passed a special resolution. Indoor management. The company will be liable to repay the whole 60 lakhs to the bank. Correct? The persons dealing with the company are always protected by the doctrine, and also where constructive notice will apply. Constructive notice says that any document which is filed with the registrar, under section 399, it is a public document, and every person dealing with the company is deemed to have knowledge about it, right? You just have to explain indoor management and write the lochas here and talk about doctrine of constructive notice. There are cases where the company law disregards the principle of corporate personality. I already told you the cases where the wheel is lifted. When the company is formed to evade taxes, where the company is a sham or a fraud, where the company is formed to for avoiding welfare legislations or to determine the true character of the company. In all of these cases, or where the company is an agent. In all of these cases, the wheel is ANSSC. We have already done this, right? This case was Sir Dinshaw Manikji Petit. Not going into it again. Yes. The object clause of the memorandum authorized the company to carry on the business of trading in fruits and vegetables. The directors in recently concluded board meeting decided and the company ordered fish for the purpose of trading. Can they order fish? You are supposed to deal in fruits and vegetables. This is outside the authority. Right? FSH supplied fish and FSH is also a fool. Did you not go and read the documents? The members of the company convened an EGM and negated the proposal of the board of directors. FSH Limited, being aggrieved, wants to go seek your advice. No remedies. Can we say they will have no remedies? We say they will have no remedy. Nikita, board of directors don't have the authority. You have to alter the MOA, and to alter the MOA, you need the consent of the shareholders. ABC Limited was into sale and purchase of iron rods. This was the main object of the company mentioned in the MOA. The company entered into a contract with Mr. Jones for some finance related work. Later on, the company repudiated the contract as being ultra vires. Briefly explain the doctrine of ultra vires and what are, I've already told you I'm not doing. Okay, we've already discussed this. What is the meaning of certificate of incorporation? What are the effects of registration? Certificate of once the company is incorporated, the ROC shall issue a certificate of incorporation to the company. Once this certificate is issued, it's an evidence that the company has been incorporated. A separate legal entity comes into existence. This person is separate from its members. What is the effect of registration? The effect of registration is every subscriber becomes a member of the company. An artificial person comes into picture. This artificial person has a perpetual succession and has the capacity to hold property in its own name and a capacity to sue and be sued, right? So the company becomes a distinct legal entity. It acquires a life of perpetual existence by the doctrine of succession. The members may come, but it is unless it is wound up, it will be existing forever. The property is not the property of the shareholders. They have a right to the profits, and when declared dividend, they have a right to the profits. Parab Limited was incorporated by acquisition of Parab and Company, a partnership firm which was earlier involved in many illegal activities. The promoters furnished false information and also suppressed some material facts at the time of incorporation of the company. Some members of the public approached the NCLT against the incorporation status of Farib Limited. NCLT is about to pass the order to make the liability of the members unlimited. Given of the above advice on whether the above order will be legal and mention the precautions. Well, yes, when a company is formed by giving false information, and the tribunal may pass an order making the liability of the members unlimited under Section 7. However, whenever this order is passed, before passing this order, the NCLT shall take into consideration all the contracts already made and give the company an opportunity of being heard. Right? Sound Syndicate Limited, a public company, its articles of association empowers the managing agent to borrow both short and long term loans on behalf of the company. Mr. Little, the director of the company, approached managing agents can borrow. Mr. Little, the director of the company, approached. He's the director of the company, so he is a managing agent. Approached Easy Finance Limited, a non banking finance company, for a loan of 25 lakh in the name of the company. The lender agreed and provided the above said loan. Later on, Sound Syndicate Limited refused to repay the money borrowed on the pretext that no resolution authorizing such loan has been actually passed. Can you refuse? No. It says that your managing agents have an authority to take long and short term loans, and your director took a loan, so you are liable. Refused on the pretext that no resolution authorizing such loan have been actually passed by the company, and the lender should have acquired about the same prior to providing of such loans, and the company is not liable to pay such loan. So, can whether the contention is correct? No, it's not correct. Since he is the director, it is as an outsider. My only concern is to check whether the company has the authority or not, and the person who has the authority or not. How the authority was given is not my concern. So, contention of the company is not correct. What do you mean by the term capital? Capital is the capital of the company divided into rupees. What are the different types of capitals? Nominal capital, that is the total amount of capital that the company can raise by the issue of shares. Out of this, whatever portion of the capital the company decides to issue is known as the issued capital. Of this, whatever is taken, could be the whole also, is the issued capital. Whatever amount the company has called up is known as the called up capital, and of this called up capital, whatever amount the company has received is called the paid up capital, right? The memorandum of association is the charter of the company. Discuss also explain in brief the contents. Yes, it is, tells us the powers of the company under section 399. It's a public document and every person dealing with the company has knowledge about it. It tells the public what is the authority of the company, and also informs the shareholders about where the money is utilized. This memorandum has 6 clauses: name clause, registered office clause, object clause, capital clause, liability clause, and in case of an OPC, it has a nomination. Right, this was the last question. Any doubt you have, you asked me today. I was a little under the weather, so I was not in that whole, the josh of the discussion. But still, I hope everything it was clear to all of you. If you have any doubts, yeah, no class, correct. If you have any doubts, you ask me. Otherwise, we'll end. Okay. So, I mean, contract act, because I couldn't take the class yesterday, so I could not take contract act. I'm traveling tomorrow, so I don't think it would be okay for me to take the class at 9 o'clock. But still, if by any reason it works out for me, I will, even if okay, I'll let you all know at 8:30, quarter to 9 also, but mostly it won't be possible. So, today, I don't know, Hinal. Today I was not in my form, so I don't know it was an amazing session or not, but thank you for your words. So I'll see you once or twice again with my videos here and there, or I'll come live. I'm planning to come live at least on the day of your exam once on Instagram to check on you guys before you go for the exam. Until then, all the best. You guys rock, you know that. All the best. Keep studying and sleep well. That's very important. Have a good sleep. And if you do, you will be energized enough to write your paper better. Chalo. Okay? I will see you all again soon. Good night, good night, good night. Bye bye. All the best, all the best. Study well, eat well, sleep well. Okay? Chalo, thank you. I'll end the session.